first case to come before the court today is State of Ohio v. Louis Otero. Each party will have up to 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. Please introduce yourselves. You should not use the names of children or minors or victims. You can use generic terms or initials for those individuals. And I assure you that the judges have read your briefs and we're ready to proceed when you are. And I guess at this point, I would just ask the appellant, would you like to reserve time?
I would like to reserve 5 minutes, Your Honor.
Very well, then we are prepared when you are ready to go.
Good morning, Your Honors. May it please the court. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the appellant, the State of Ohio. The state asked this court to reverse the trial court's decision to dismiss this matter because of a speedy trial violation for a second time. The state does so for the reason that in dismissing the indictment, the trial court erroneously relied on Adams to conclude that tolling events in the previous matter do not apply to this case. Based upon its legal conclusion that the tolling events from the previous case did not apply to this matter, the trial court did not conduct any tolling analysis. Under the circumstances of this case, the trial court's decision not to consider tolling events was contrary to the Ohio Supreme Court's decision and in Blackburn, and its reliance on Adams was misplaced. Blackburn explicitly provides that in calculating speedy trial time, periods of delay resulting from defense motions in a previous case also apply in a subsequent case in which there are different charges based upon the same underlying facts and circumstances of the previous case. This is a subsequent indictment case. The state maintains that certain delays resulted in statutory tolling of time.
Was Blackburn also a subsequent indictment case? Or was it dismissed and refiled, do you recall?
I don't know if there was a refiling. But Adams involved a waiver of time and simply does not apply in this case. And Adams is what the trial court relied upon.
Was Adams also a dismissed and refiled or a subsequent indictment case?
Subsequent indictment. Here, Otero was indicted on felony charges arising from the execution of a search warrant at a residence belonging to both he and his brother in both a previous case and in this matter. Specifically, during the execution of a search warrant, police recovered cocaine from Otero's person and drug trafficking items from the residence. Police also discovered presumed drugs with a large amount in a yard next to the house under some shrubbery. Otero was arrested that day on August 18, 2020, and only charged for the drugs found on his person and in the house, and not for the yard drugs, as we will call them, which had also been discovered. There are a lot of dates in this case that are relevant, and a lot of dates that will be thrown around, but some of them are relevant and pertinent to the procedural history, and I'll go through a few of them. So, Otero was arrested on August 18, 2020. He was jailed until August 31st, 2020, and then police sent out the yard drugs to BCI and got a lab report back on approximately October 9, 2020, confirming Otero's DNA on the yard drugs. On October 28, 2020, Otero was indicted for the drugs found on his person. On May 5, 2021, Otero pled guilty to the previous case after having waived time. On June 10, 2021, he was indicted on the yard drugs case. He was sentenced on July 21st, 2021.
I'm sorry, he waived time in the first case?
I'm sorry.
He signed a time waiver in the first case?
In the previous case.
In the previous case, not the newly filed case?
Correct.
Subsequent case. Thank you.
and he was served with the yard drugs indictment on July 22nd, 2021, and his motion to dismiss soon followed. As this procedural history makes clear, Otero was indicted on different felony charges in this case based on the same circumstances as a previous case. Therefore, the rule of Blackburn must be applied such that tolling events in the previous case apply equally in this matter. Based upon the state's calculation in its brief, which it has charted out for this court's review, after accounting for tolling events across the previous case and in this case, only 167 days of Otero's 270 day speedy trial clock elapsed before the trial court's erroneous dismissal of this case for a speedy trial violation. And as the state
Counsel, is the
Yes.
difference here, that if I understand your argument, Adams doesn't apply, Blackburn controls because one, Adams deals with the waiver, and Blackburn deals with the statutory, operation, is that correct?
correct. Blackburn applies to statutory tolling and Adams applies to waiver. And Adams applies to the fact that waiver from one case does not apply to waiver in a second case. Blackburn is simply a statutory matter, a statutory tolling matter.
Thank you.
The state argued in its reply brief as well that Otero himself has seemingly conceded that the trial court's conclusion that tolling does not apply was incorrect by acknowledging that the issue and the question itself turns on tolling. Examples that tolling events in the previous case examples of the tolling events in the previous case include defense continuances at the defendant's request, the filing of many motions to modify bond, and his plea, all of which operated as tolling events under 2945.72. In this case that was dismissed, the biggest tolling event was Otero's own motion to dismiss the indictment, which then led to the state's successful first appeal of the trial court's decision. What's more, although faulty, Otero did his own tolling analysis in his brief, which lends support to the conclusion that a tolling calculation is outcome determinative of this appeal. Based upon what is a seemingly agreed upon error in the trial court's central legal conclusion regarding the inapplicability of the tolling events from the previous case, the trial court's decision dismissing the indictment is clearly subject to reversal. At a minimum, this court must reverse and remand this matter for the trial court to conduct a tolling analysis of its own in the first instance. Because there was no violation of Otero's speedy trial rights and the trial court concluded otherwise, the state requests that its decision be reversed.
Let me ask you, the trial court's decision, as I recall, started the clock for the statutory purposes in the middle of October 28th, I recall.
Okay.
In your brief, you go back and start in August 18th, date of arrest. Do you agree then the trial court was wrong in picking that mid-October date? It should have started the clock on the date of his initial arrest?
Yes.
Okay.
Thank you. I reserve the remainder of my time.
Okay, thank you, counsel, you will have your full 5 minutes on it.
Thank you.
Good morning.
Good morning.
Giovanna Bremke on behalf of Mr. Otero. We are here again on Mr. Otero's case. This is a second appeal in this matter. As this court's probably aware, the case was once already reversed because of the trial court's order, which didn't have enough of a decision. I mentioned that from the start because I think the state is alluding to or making an argument that, again, the trial court's decision was insufficient. But I would argue that these continued reversals on this matter continue to harm Mr. Otero, in that, while he's still incarcerated, if this ultimately is not decided in his favor, this time is still running, and, he's serving time. Second, he has this continued, cloud over his head, the continued payment of defense on appeal, and so I would ask that the court proceed with making a decision. I know that Judge Stevenson mentioned about Blackburn and whether that was a subsequent indictment or a refile, and that was a refile. So there is somewhat of a distinction there. They actually dismissed it and then refiled. This case is really unique factually because the initial informant came to the police with the information that there was drugs specifically in a yard. And that's ironically the indictment that came much later. And, presumably it was a result of the officers not sending it out to the lab for a long period of time. But I've repeatedly argued in speedy trial cases, speedy trial is there for purposes of human error and mistakes in which the defendant suffers, and this is a prime example of that. The state admits, and I've repeatedly cited to that, right off the gate they say the state is wrong in this. And the state has repeatedly argued various versions of calculations themselves. The reason that I bring that up is because in my argument, and it's towards the end of my brief, I mentioned the fact that the state has the burden of showing whether speedy trial was violated. There was a hearing in this matter. The hearing only presented one witness, it was the officer, and really didn't present enough there to show the tolling or any kind of triple count or anything of that nature. The officer, with respect to him, didn't have a lot to argue as far as, didn't have a lot to offer as far as the calculations in this regard. It would have been more important for the state to offer someone as far as the jail calculation or the clerks to show these different filings and the subsequent filing, all of that nature. And I know, Judge Lindsay, I think you're trying to ask, okay, I didn't want to stop you. So again, that is the Homan case, H-O-M-A-N. The state has the burden of proving the calculation. And when they originally started this argument in the trial court, they were actually trying to argue that it didn't relate back, which again is mind-blowing to me. I still argue in here that it does relate back, although I think the state is now conceding to that. But it's clear that it relates back. The state could have charged on that night. They knew about it. Their initial informant, again, was specific to that subsequent indictment. All of the information for that subsequent indictment were learned on the day of the arrest.
I do have a question. Are you conceding that the state is correct that because the trial court didn't take into account any tolling event, that there's an error here? Because your argument is that there are tolling events here.
I do go through a lot of the tolling events. I did that last time as well because the court didn't address those issues, and I did that for the purpose of the court if the court is able to get there. But I think, again, we have this Adams case and we have this Blackburn case, and I think that the court's entry is not, it does talk about the Adams case. I don't believe it mentions the Blackburn case, but I don't think that it's flawed in not mentioning the Blackburn case because I don't think it gets to the tolling. What my position would be is that it talks about Adams, which stands for the fact that this waiver doesn't apply to the subsequent indictment. And that's true in this case. There was this waiver, and it doesn't apply to the subsequent indictment. What I would indicate to you all is that the court, in not mentioning Blackburn, is saying, hey, this tolling, I find that even with the tolling and all of that, there wasn't a violation here. So while the court doesn't specifically get into the tolling events, I would submit it doesn't need to get into the tolling events because by nature of its decision, it didn't get there because it says, this waiver doesn't apply, and regardless of these subsequent events, it still was a violation of speedy trial. So while it doesn't specifically address the tolling, that's something that the court would have taken into consideration. And again, that's something that the state has the burden of proving. Any inadequacy in that entry, I think should be attributed to the state and not proving their case. Again, there wasn't any testimony as to this tolling whatsoever. I go through a lot of these tolling events, and it's very mathematical, and I don't know how much, I really want to get into those, but, some of them are very interesting arguments as far as tolling goes. I did that again for the benefit of this court if they want to get into, into those issues. Things like a non-time stamped, non-docketed discovery motion that the state in their brief, and we kind of both have these little charts, but about how we calculate, but the state applies that again against the defendant. My argument would be that that's not a filed document, shouldn't be counted against the defendant. Things about the, a bond motion and how long that bond motion would toll time. There is some case law that I cite, this Caudill case that seems to indicate that that's around 11 days. There's a lot of entries, and this is, for context, during a COVID period where Mr. Otero wasn't being transported to the court, he wasn't signing entries, and neither was his counsel. So there's a lot of these entries where it's saying, at the defendant's request, we're continuing this, but there's really no indication that Mr. Otero or his counsel had agreed to that. So these are pre-printed entries that the state produces, that are repeatedly, they're trying to hold it against Mr. Otero when he's not even brought to the building, he's not consenting. There's nothing on the record to indicate he would ever even have seen that entry.
Were the records of those individual hearings submitted to the court on the appeal? In other words, if they're saying January 22nd, there was a continuance in this case, and you're saying there's a pre-printed form saying, at defendant's request, is there a transcript of that January 22nd hearing so we can review what exactly happened, whose request it was?
No, but I'll tell you, there's no transcript because there was nothing on the record, and that's what I'm indicating is, how could Mr. Otero, it's not even clear to me that Mr. Otero was ever, again, he wasn't brought to court. There was no transcript because there was no hearing. So it's saying that he's requesting a continuance, but he's never even brought to the court. There's, as far as the record goes, and I can't, I'm stuck to the record like you, I can't even tell whether they even ever had a hearing. So there's no transcript because there was never anything on the record at
But
all.
there's a signed order by the judge, you're saying?
Correct.
That says that it was at the defendant's
The
request.
judge and the prosecutor, but never Mr. There were, some of them, I don't want to say never, some of them are signed by him, and I think there's one that's signed by his counsel, but not him. But there are, I think I have 4 that are not signed by him or his counsel, just the judge and the prosecutor, for a long period of time there. He wasn't, there's no record because there was,
And
as
these
far as the
are
record
what
goes.
we call pre-printed forms for the continuances, that you say that automatically, that it's not a generated after each hearing type form.
Correct. This is a form generated by the state, that is every defendant, has that. And, ordinarily, there may be a waiver provision that counsel would scratch out, but again, on 4 occasions, counsel never even signed these entries. There's no indication that counsel even saw these entries. So, it would be, again, I think these are things that the trial court, although the trial court didn't explicitly put in its decision or its entry, it would have considered that, and it would have been in the best decision to consider that, as the individual or as the court that was presiding over the case. So.
I hate to do this to Mr. Otero, but based upon that comment, if this court were to find there was some error in the court's decision to not follow Blackburn and have tolling events, how would we have how can we do anything else but to the back of the trial court to say, you need to look at your record and tell us where they're tolling? How are we supposed to make that determination?
Well, there is some case law that I cited, and I don't know the name of it, but that the Court of Appeals can make a finding of the exact time frame in which the calculation would be. I don't know if it's shall or.
I think we may, I mean, it would make sense we may, but in this instance where you're saying, look, we just can't trust these records from the trial court to say whether things were waived or not.
Right.
How is anyone but the trial court going to make that determination?
Well, again, I think that any ambiguity in that regard should be, it should go against the state's argument, because they're the ones who haven't provided that. The tolling wasn't brought up, it wasn't argued. This hearing had one officer. I mean, it's common sense that the officer wouldn't be able to talk about these tolling events other than when he sent out the for the lab. But as far as these arguments that I'm making in the entries and when those are filed, really, perhaps call the clerk, someone from the jail to show when he was in, when he wasn't in. There was no testimony with regard to that. The case I'm talking about is State versus Riley, in which it says the appellate court should calculate the days charged to the defendant. Again, I would submit to you, I know that that's a tempting argument to send it back to the trial court for further clarification, but it is extremely detrimental to Mr. Otero to have to continue to endure that. But I would say that the trial court was in the best situation, that this court should defer to the trial court's decision, and that although the trial court didn't explicitly state it, the trial court would have been in the best position to determine those tolling events, and just because it wasn't explicitly stated doesn't mean that it wasn't contemplated. Any other questions? So we would ask that you, unusually for me on this side, affirm the trial court's decision. Thank you.
Thank you very much.
Here, the trial court simply did not take tolling events into consideration in issuing its decision. That was an error under Blackburn. I believe that the appellee, Otero, just stated that the court was in the best position to determine tolling events. That's the summary of the state's argument. This court should reverse and remand for the trial court to do so. Otero also stated that the state conceded in some manner that it was wrong at the trial court level, and that the burden of showing whether a speedy trial violation occurred is on the state. That is not a correct statement of the law. The burden in showing tolling, once Otero showed that a prima facie case of speedy trial violation had occurred, the burden shifts to the state to show that tolling events occurred. That burden we submit, the state submitted evidence of tolling events at the hearing after it submitted a supplemental brief to the trial court and argued that position, and has argued that position consistently throughout the appeal. The court simply did not take tolling events into consideration in issuing its decision, and this court should reverse and remand at a minimum for the court to enter a tolling analysis on remand.
Counsel, do you have anything in response to Attorney Bremke's argument that Mr. Otero never really requested a lot of the continuances?
I would submit that that's not an appropriate argument to be made at this time in regard to the fact that that argument was not made in the lower court. And, I'm sorry.
Okay, thank you.
Thank you.
Any other questions? Okay, hearing none, the court will take the arguments under advisement, and we will issue a decision in due course. I thank you both for your presentations. The clerk of courts will mail that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you.